21 and 22.
Yes.
Yes, Lordship, in this matter, it was passed over for today. And last night I was called up by AG that the government wants his view in this case, and AG is asking for the file, so he needs some time. So, Lordship, I pray this meeting may come in the month of April. Yes.
We had it today.
Yes, Lordship. I even conveyed the same to AG, but he got the instruction from the government seeking for his view.
What to do, Mr. Zivumi?
Why is that ready one?
This court is also ready.
Yes.
Only government is not ready. This matter is pertaining to 2021.
Exactly, Lordship.
What to do?
If the AG can give a proper legal opinion, it's beneficial to both parties.
And the AG wants to appear.
Lordship,
The government wants the AG's views.
Yes, AG's views, yes, Lordship.
Okay, right. I think we'll get it. Heard Miss Sokre, additional AG, Nagaland, who submits that the matter may be adjourned, in as much as the government wants the views of the AG, the learned AG, prior to disposing of the matter. Mr. A. Zimomi, learned counsel for the petitioner, submits that he has got no objection to the same. Accordingly, leave this matter on
In the month of April, Lordship.
April.
Yes, Lordship.
March.
Why April, madam?
Lordship,
He's not
because he
coming.
has been engaged with other some Nagaland.
Give me a date. Give me a date.
Give me date in April, Your Lordship. No.
15th April. Make it second, first, second,
Second. Okay,
Second.
Lordship.
April 2nd.
Much better.
Much better.
May I please, Lordship. My Lord, I bet imagine item 7. I am for the private respondent. I have taken a consent from the council petitioner. Lordship, may kindly give me 2 weeks time to file everything in opposition, my Lord. I was out of station for my family
Okay.
checkup for some days.
Okay. Mr. Azo, learned counsel for the respondent number 5. Is granted how much time?
2 weeks just.
2 weeks time to file affidavit in opposition. This is the matter of 2. But Mr. Counsel, it's a simple thing.
My Lord.
The only issue is whether advertisement was issued or not. That's all. Nothing remains besides that. That is the only thing. What are you going to say? You are buying time only for what?
That I just wanted to file everything. It was such to be. I wanted to do justice to my client. I have not.
No, you have got to do justice to the court, to the justice system.
My Lord. Yes.
You see, at the end of the day,
Yes.
the entire issue boils down to whether the advertisement was issued or not. If it's not issued, the end of the matter.
He is claiming on the strength of land ownership.
Petitioner is claiming,
Yes.
but you're claiming on the ground that you were appointed without any selection process.
Give me 2 weeks time. I'll certify, Lordship.
Okay. Order, huh? Same.
Major.
Lordship, I beg to mention item 3, Lordship,
Yes.
on behalf of Alan Homer. If 2 weeks time you granted to me, Lordship.
You're for the government. Why are you not paying the money?
Lordship, I'm not in this matter, Lordship. I'm appearing on behalf of my colleague, Lordship.
Who is for the petitioner? Not yet. Okay, right. On the prayer for you're for the petitioner.
Yes.
Item 3. You have not been paid the salary.
Since 2021 July.
Madam, what is this? 2021. You're working as what?
Yes, I'm still.
As what?
Workers.
Outside employee.
For 2 weeks.
Why? Who's the government advocate? Acha.
Lordship, there is some miscommunication. This matter is handled by me, Lordship.
By you?
Yes, sir.
Very good.
Your Lordship,
You're the right
I
person.
may be given 2 weeks time to file affidavit. Your
Madam,
Lordship.
why are you not paying money? So,
Your
He
Lordship, there
needs-
is some discrepancy in the PIMS, so
in the
PIMS entry.
PIMS?
Personal Information Management.
But
System.
then that you correct. But in the meantime,
Yes.
pay him.
Your Lordship, they are work charge employees.
So
There
you
was
see-
a direction as well. Your Lordship, let me, allow me to file a detailed affidavit, Your Lordship. Regarding the status as well, Your Lordship,
which department?
PWT. Just 2 weeks, Your Lordship.
No, you see the issue is this. You see the issue is payment of salary. They don't get very much. They need money to keep everything home and hearth together.
Your Lordship, there was a direction, there was some, direction as well, Your Lordship, for the, directing the petitioner not to attend work
Oh,
during the.
Not to attend work.
During the verifications.
and he's still attending work.
Your Lordship, that regarding.
I'm still starting my this.
They've asked you not to attend and you're still working.
Yes, sir.
Nothing as such, so.
Nothing. Is it written in writing or verbally?
Your Lordship, there's a notification as well, so I may be allowed to next step in my affidavit as well, Your Lordship.
Okay, Miss
In a holy, Your Lordship.
in the Holy Learned Government Advocate is granted 2 weeks time to file written affidavit in opposition. This is a matter of opposition.
Much obliged. Your Lordship, as also item 4, Your Lordship. In item 4, Your Lordship, I have sent the affidavit for vetting today, Your Lordship. So it may be listed after 2 weeks, Your Lordship.
Miss Ina Holy submits that affidavit has been sent for vetting. He submits that the same will be filed within 2 weeks. List the matter after 2 weeks.
Much obliged.
Thanks, Your Lordship. Your Lordship, I would like to mention item number 20 from the supplementary list. Your Lordship, here the leading counsel have some personal difficulties today, so if it can be fixed on 16 Monday. He's an outstation counsel, Your Lordship.
This for what? What is this matter about?
Your Lordship, I'm not in this case.
You're not in this case. Who's asking for time?
Muhammad Kaish Udin. He's from Gauhati, Your Lordship.
Any stay order on the prayer for adjournment made on behalf of the petitioner's counsel? List the matter after 2 weeks.
Lordship. Lordship.
I'm sorry. Also, I beg to mention item 16.
Yes.
That is come out after 3 weeks, Lordship.
Why?
In one connected case, there's a appeal pending.
Appeal pending where?
In one connected case.
What is that? What is the connected case?
Same petitioner, but
There's no connection.
This is the issue of recovery of excess pay.
no.
Then
Well, if I
Where is
if
the
the
connected?
if the other witnessing is
we decide tomorrow, both of them. How does it matter?
tomorrow, it's
Or day after tomorrow?
yeah, day after tomorrow. Day after, Lordship.
Okay, on the prayer of Mr.
Gauhati.
Gauhati, Learned CDC. List the matter day after tomorrow.
Much obliged.
Along with WPC number?
No, one is
Appeal.
real appeal. The other one is real appeal.
Day after tomorrow, huh?
May I please, Your Lordship? I beg to mention item number 8.
18.
May this matter be listed after, Your Lordship. My senior has some difficulties.
What is the matter about, madam?
Lordship, it's about a grade 4 land ownership agreement.
Land ownership.
Lordship.
You're the landowner.
Yes, Lordship.
And you're the,
Respondent number 7.
so challenging your appointment. Was there any advertisement?
Let me see.
Who's your senior?
City Jamir, senior.
Where is he?
He's out of station, Your Lordship.
Supreme Court has said that.
Let the matter be listed
Supreme
next.
Court has said that out of station can no longer be an excuse.
Next week, Your Lordship.
Yes, pleadings are complete or not? Pleadings are, have you submitted affidavit?
Yes. Yes, yes.
Then what is the need for CT Jamil?
Your Lordship, senior is not here.
Well, it will fix on coming Tuesday. Aspects item.
Okay, right. On the prayer made on behalf of Mrs. CT Jamil. And as all the councils submit that pleadings are complete, list the matter on Tuesday. Hey, this way, everything is going to be adjourned. You are coming one by one and
Lordship, I have instructions to appear in item number 8.
8.
Yes, my lord. Respondent number 1. Kindly give me 1 week time to file my Baklaten affidavit. This is a matter relating to custody of a minor child.
Visitation rights.
Yes, ma'am. I was granted overnight visitation right. They agreed by that.
You were granted visitation rights.
Yes, ma'am.
Overnight.
Overnight visitation rights. Once a month.
How does it matter? Once a month.
Lordship, it's infant, Your Lordship. Only 3 years, Your Lordship.
So,
And the mother is the primary caregiver, Lordship.
3 years, so
About 3 years.
no longer breastfeeding.
Yes, my lord.
Mr. Akito, you're there.
Lordship, when I was moving this case, I relied upon an authority by the Supreme Court, where the Supreme Court says 3 years, 3.5 years is of too tender an age, should not be out of the custody of the mother.
But then there are other judgments also.
A recent judgment by the Supreme Court.
Maybe. But then, as you know, the Supreme Court has said also when there are two conflicting judgments, the earlier one should be,
Of course.
should be followed by the High Court.
They didn't find a counterpart. So it's not,
No, it's an issue of one night. One night? Why don't you allow once a month at least one night?
Your Lordship, let the matter be heard.
No.
Find a counterpart.
One. I mean, you see, you are asking for one night a month.
Yes, my lord.
One night in a month, how does it matter?
No, my lord, it's not 1 night a month. What has been ordered is not 1 night.
What has been ordered?
It's
During holidays, maybe 2 nights.
yes.
During Christmas, holidays, and this thing, very reasonable order, my lord. Very reasonable.
So it's not just once a month.
And my lord, the minor child won't be going to any alien place. She will be coming back home to her native place where she was born and brought up. She was born and brought up from Sama village. And she will be coming back home.
Not that. But how many times in a month?
1 month, my lord.
No. How many times in a month do you want to take the child?
A visitation.
It cannot be every weekend because the mother also needs.
I'm not seeking every weekend, my lord.
When do you want?
Just once a month.
Once a month.
Yes, my lord.
No,
And visitation right, so it's a second Saturday and fourth Saturday.
Your Lordship.
No. Overnight is once a month.
Yes, my lord.
No,
Overnight.
my lord. No.
Overnight
My lord, may kindly
No, we
speak-
can correct that. No, we can correct that.
Of course.
We can correct
The order is not
that.
like that.
Okay.
The order is at page 34. The schedule is at page 34 of my writ petition.
Bill 34. Yes.
It's not just once a month, man.
No. That you see, this order, we can change the order. Doesn't mean that you see, we can change the order as long as it is acceptable. You see, one thing is that prima facie this court believes that you should give overnight stay also. He's saying once a month, you give once a month. Visitation rights, he's getting visitation rights, that's a different thing. But we will modify this order.
Yes, my lord, please.
We'll modify this order, we'll record his statement.
My lord, I'll have to discuss that with my client.
Because
The child is still, there are attending circumstances here. And
like,
attending circumstances in a sense, The circumstances in the paternal home are not very conducive for a child. Paternal circumstances.
Those are, you see, those.
My lord, those factors also have to
My
be
lord,
taken into consideration.
the
So let them file an affidavit. my
the
lord.
indifference between
short
me and my
period.
wife should not hamper the. That's
You see,
benefit of-
because look, I'm also having this special bench in in party. I'm dealing with all these family men. So we have got number of cases like that.
My lord.
Number of cases. And this is a very reasonable request that is being made. Very reasonable.
So let them file an affidavit, my lord.
No, if we
It's
can,
not-
if we can dispose it
Your
of.
Lordship, as far as
That will be my humble.
As far as the submission that he's making, my lord, I can say that it is not what his client wants. Because it's what his client wants is a different thing altogether.
My
This
client
is an
will
off-the-cuff
be,
remark, man.
my client.
No,
will
but
be
then
more
if we
than
put it
happy.
in black and white,
Yes,
that's
my
the end of the matter.
So let them file the affidavit, my lord. Then the matter can be, a short date may be fixed, let them file the affidavit, we'll hear the matter. We'll hear the
Fine,
matter.
my lord. Friday,
No, Friday I'll not be here.
Thursday?
fine, my lord. I will-
No,
I'll file it.
your lordship, Thursday, Friday will be a problem for me.
Why?
Lordship, I'm here again tomorrow. I have some matters to argue before the division bench tomorrow. And Thursday and Friday will be a problem for me.
The junior would be here.
No, my lord, this is a matter which has been entrusted to me by the client specifically. I have to take care of it.
You see, you cannot just not allow the father to also have overnight stay once a month at least. That is a very reasonable restriction.
My lord,
We'll modify this order then
yes, my lord.
in the meantime.
No, my
Once a month is a very reasonable order. It's very reasonable. Once a month, we'll put it in black and white.
So let the affidavit be filed, my lord, and let the matter be heard in its entirety.
You see, out here, this stay also was without thing.
If they want to file an application for modification, let them file, my lord.
Tomorrow, my lord. I'll file my affidavit tomorrow.
So when did you all separate?
February 2025.
Yes, my lord.
When did you all marry?
January 2019.
Then why did you all separate? What was the reason?
Your lordship, the respondent stopped communicating with the respondent altogether,
With the appellant you mean?
with the petitioner, my lord, in this petition. With the petitioner.
This is the WPC.
Yes, my lord. From the order of the family court.
That has to be an appeal.
No,
That has to be an appeal. It's a matrimonial appeal.
From the family court, my lord? Petition under 227, my lord.
Anyway, out there, we do it, it's an appeal.
But for us, we don't have any such avenue for us, my lord. For us, we come by way of 227. Anyway, my lord, if I may-
Maybe 227, but it's an appeal. It's an appeal. Because 227 is only with regard to jurisdictional issues.
My lord.
And any order of a civil court or family court for that matter has to be challenged by way of an appeal. This is a judicial order.
My lord.
A judicial order cannot be challenged in a writ petition
My lord.
unless it is in matters with regard to jurisdiction.
227.
So out here, jurisdiction is not the issue here.
What is the issue here, my lord, is not following settled law. Not following settled law.
I think the issue, it has to be an appeal. Cannot be 226 or 227. We'll take it up tomorrow. We'll be ready. But I don't think 226 will apply or 227 will apply. You have to file an appeal. A judicial order can only be challenged by way of an appeal.
That is settled also. I'm aware of that.
You are aware of that. So this 227 will only apply if you feel that the
If there
court
is-
does not have the jurisdiction.
And if there is no appeal provided.
If there's no. Correct. We'll list the matter tomorrow. The question of maintainability of the writ petition will be considered.
Lordship, interim may be extended.
It is in order to continue till tomorrow.
May I please lordship? Slow mention hearing item 17. I've taken a consent of the state council. I have to file IA for pleading three respondents. Which I've withdrawn the IA because of defect in the IA. On 8/12, I've withdrawn the IA application.
You have withdrawn the earlier IA.
Yes, please, one. IA 212.
So you have to withdraw and show me. Show me this item 17. All the entire file. Is there any IA of this? Okay, so you want to file a new IA?
Yes, my lord.
Okay,
I mean, we don't know which time.
Mr.
I am Pakin Vichabu.
Learned counsel for the petitioner
Yes, ma'am.
submits that he would like to file a application for imprisonment of parties accordingly release the spender after 2 weeks.
For 2 weeks. Leave it.
Yes.
For motion, item number 1.
May it please your lordship. The lord the petitioner is a PWD, person with disability. She has locomotor disability more than 40%, my lord. She has applied for the grade 4 post under the civil secretariat. There are 505 posts of grade 4 employees, my lord, out of which only 2 persons are persons with disability. And the notification of the state, my lord, 13 August 2020, it should be 4% of the
Okay,
total
yes.
number of vacancies.
I want to submit that the petitioner, he does not have a case, and it is premature, your lordship, because what he is bringing is that he is asking for the whole 4%. If we look at the notification, her benchmark is only 1%, your lordship, only 1%.
Benchmark of disability.
Yes, benchmark reservation for her is only 1%, your lordship.
So,
And he's saying that.
no, so which post have you applied for? This is not a PIL.
Yes,
Which post have you applied for?
Grade 4, your lordship.
Where? Which
Lord, the
advertisement?
representation,
Grade 4, but in respect of which post, which advertisement?
any post, my lord. Any
Any
post where the persons with disability can be employed. In fact, respectfully, my lord, my learned friend is making a submission which is, it is confusing. I do not know what my learned friend is saying. Because the policy is that 4% should be persons with disability. And it is not a post which the persons with disability cannot be appointed. Now, my lord, 20 posts out of 505, 20 posts should be with persons with disability, but there are only 2 persons with disability appointed. Now, my lord, presently,
You see, Mr. Counselor, we know that. The issue that there should be reservation, we know that. But for which post have you applied for?
Grade 4 posts.
Which advertisement? There's no advertisement issue.
There is no advertisement, your lordship, but what is happening is, instead of making any appointment, backdoor appointment is going on, your lordship.
Yes, that is one thing.
lordship, but we have to see that if your lordship come to page 18, it's very clear that
Page 18.
This is the notification dated 13 August 2020.
Yes.
At point number 2, quantum of reservation, your lordship.
Yes.
In direct recruitment, 4% of the total number of vacancies in the gathered strength in each group of posts, A, B, C, and D shall be reserved for persons with benchmark disability, of which 1% shall be reserved for persons with benchmark disability under Section 34, Clause 1, Subclause A, B, and C. Lordship, if you see C, she comes under C, locomotor disability.
Yes.
So it is only 1%.
Correct.
And he's saying that there are 505 posts. Your Lordship, the disability.
So 1% of 505 posts will be 5 posts.
Yes, but Lordship, the disability came into force in 2016. So we cannot count those persons who were appointed prior to 2016, Your Lordship. So it must be only 152 posts, Your Lordship. 152 posts of grade 4, Your Lordship. Out of that, only we have to make the percentage. So her post comes only to 0.06, Your Lordship. So it is not even 1%.
I don't know. He's saying that there are 505 grade 4 posts.
So for that, I'll show you, Lordship.
Respectfully, my lord.
If you come to page
allow me.
29, Your Lordship.
No. You see, 500, page 29.
Page 29. That 505, Lordship, if you see date of joining,
yes,
these are the people that joined in 1990. Yes, so we cannot count these people, Your Lordship, because Disability Act came into force in 2016, Your Lordship. So if we have to count from Lordship, we come to page 39. We have to count from serial number 279.
Yes.
Yes, the appointment is 24/2016.
Yes?
Yes. So Lordship, now the petitioner does not have a case. It is premature, Lordship. So it has to be
No,
displayed.
no, he's asking that whenever there is a recruitment process done.
Yes, that's what we will do it. Your
Now,
Lordship.
so according to you right now, how many posts are there, grade 4 posts?
It would be 152 after this one,
After?
after 2016.
Right?
At present,
No, no,
because
no.
we cannot calculate, we cannot count the.
No. No.
Because they are still in service. Those
No.
people, they are still in service, Lordship. Yes.
Maybe.
Mm.
But wherever, now, whatever posts there are,
Mm.
the sanction posts, 4% will have to be now reserved.
Yes, 4% will have to be reserved.
And out of that, 1%
Percent
is for them.
Yes, Lordship.
So, as and when the turn comes,
Yes.
then you advertise the.
Yes, your Lordship.
So you find out now. Give us in black and white
Mm.
as to the number of sanction posts
Lordship.
and the number of posts filled up under the PWD Act. That's all.
Lordship.
No, my lord, respectfully, my lord, it appears to show that my learned friend has not gone through the Honorable Apex Court's order, which says reservation 4% means the total working force.
Correct.
4%, my
So
lord.
let her give the all the numbers.
Your lordship,
Let us get the numbers first, one at a time.
my lord, your lordship.
That aspect of whether that 4% will have to be considered in respect of 505 posts. Will give the order.
Your lordship,
Let us be clear with the maths first.
my lord, your lordship.
Right.
My lord, I have an interim prayer also. Your lordship, presently, the present vacancy, also on the date of filing this writ petition, there are 13 vacancies and 21 more are expected within this year, as per the list presented to the petitioner through the RTI application. So, my lord, unless some restraint is put, your lordship, backdoor appointments, we cannot guarantee that it will not take place.
Nothing is sure here. And so what we can do is let her get the figures. Then we will consider, depending upon the figures, then we'll pass the interim order on the next day.
On the next date. If not, my
Let
lord,
no, because you see, we do not know. Right now, we don't know
lordship.
whether there's going to be any recruitment process going to be undertaken or initiated also. We don't know.
No, your lordship, it is on the basis of the documents submitted to us that we have made the calculation.
This is going to be, that is not on oath. Now, this is going to be on oath. Anyway, right. Heard Mr. Joshua Shekhi, learned counsel for the petitioner, who submits that the petitioner is suffering from 40% locomotor disease. And in terms of the PWD Act, the petition, the PWD Act 2016, 4% of job reservation is to be made for persons with disability. Full stop. Out of the 4%, 1% is to be reserved for persons with locomotor disease. Full stop. He submits that there are 505 grade 4 posts at present, and only 2 persons have been appointed who are having disability as on date. He accordingly submits that the state would have to provide for filling up the quota reserved for the persons suffering from locomotor disease from the 505 grade 4 sanction post. Issue notice, Miss. Can you accept notice? Mr. Niketu, accept notice on behalf of the state. He submits that he will file an affidavit stating the number of regular sanction posts of grade 4 and the number of persons with disabilities who have been appointed to grade 4 posts. List the matter. Give a date after 4 weeks. On which date the prayer for interim order may be considered.
from the supplementary cost list for motion, item number 19.
Please, Your Lordship. This is for compassionate appointment, Your Lordship. The father of the petitioner died in harness.
2018.
Your Lordship, it is the list that has been followed. So latest, Your Lordship, the petitioner's name, which was at serial number 42, now the 12 persons have become overaged for public employment. Now his serial number has come to 30. And if you go by the state notification, up to 50%. So now, Lordship, presently, as on the date of filing this writ petition, there are 52 vacancies and 29 more are expected within this year.
I think you'll have to relook your compassionate appointment policy. It is not in terms of the judgment of the Supreme Court. The object of compassionate appointment is to give immediate succor to the family of the deceased. Now, when you appoint them after 8 years, 9 years, 10 years, 12 years, the very purpose of compassionate appointment is lost. You cannot reserve a post for compassionate appointment or, keep them in a waiting list. That is not the object of compassionate appointment.
Lordship, let the display the stage.
But you have to relook. I understand your thing. You have got your policy gives you a right. But the policy itself and the way making a waiting list, that defeats the very purpose of having a compassionate appointment scheme.
Your Lordship, respectfully, why it is happening? Because backdoor appointments is happening on a random basis and compassionate appointments are not considered. So, Your Lordship, even now in this case also, Your Lordship, unless there are some sort of interim order, my Lord, the state, they keep on dragging the petition, which I do not know about other states.
We cannot give you an interim order because your father died in 2018. You have come after 8 years. If you came straight away, that's a different thing. Now, if we give you a stay order now, it will be going against the judgments of the Supreme Court.
Your Lordship, what happens is, now they maintain a list, and the list...
They keep on filling it up.
Yes, Your Lordship. So, my Lord...
But then we cannot, you see, there's a policy, let them do it as per policy. Otherwise, there can be no challenge. You're lucky the policy is there. Otherwise, after 8 years, you file a writ petition. That Deborah Prata Saikia, judgment of the Supreme Court, Deborah Prata Saikia versus Union of India.
Your Lordship will kindly appreciate this point that since there was no movement at all, subsequent RTI applications were applied. Only after that, we came to know the position that vacancies are actually occurring. But there is no consideration in the compassionate list which is maintained by the department. So, having left...
Do you have a list? Do you have a waiting list? Compassionate appointment waiting list? Is there a compassionate appointment waiting list? There is?
Yes, Lordship.
Anyway, right. Heard Mr. Joshua Shekhi, learned counsel for the petitioner, who submits that the petitioner's father died in harness on 15/11/2018. And the petitioner applied for compassionate appointment on 23/11/2022. He submits that in terms of the office memorandum dated 17/9/2015, the petitioner would be put in the waiting list and he would be appointed on compassionate ground as and when his turn comes around. Keeping in view the OM dated 17/9/2015, issue notice returnable in 4 weeks, Ms. Chichano accepts notice on behalf of the state and submits that she will file affidavit within 4 weeks. The learned GA shall also make a specific averment in the affidavit as to whether any waiting list is made by the government in terms of the OM dated 17/9/2015, and if so, a copy of the same be annexed to the affidavit. I would not make any more comment besides that because this is against the policy.
Your lordship, oblige your lordship.
This is a matter on after 4 years.
For admission, item number 2.
My lordship, I'm appearing for item number 2.
Yes.
My lordship, the notification challenge in this petition are currently pending before Supreme Court. My lordship, our matter will be covered by the decision of Supreme Court. So my lordship may postpone this.
What is the Supreme Court case number?
Okay. So the diary number is 5898 of 2025.
Filed when?
It was filed on 1/2/2025.
And it has not been listed before the court.
It has been listed before the court, my lords, but it is not taken up by the courts.
Why more than a year and still not taken up? You all are not pushing for it, it appears. How can it be? You cannot just delay things just like this. If you're not having it listed before the court after 1 year, something is very wrong.
My lords, may adjourn this matter for today hearing. We will argue in the next hearing.
Yes.
Lordship, I have instruction to appear on behalf of my senior, Z. Kolno, for the respondents.
Who? Z. Pulna.
Lordship.
Okay. You are for who, madam? You are appearing
For the petitioner.
Okay, right. Miss Sakshi Bist, learned counsel for the petitioner, has appeared through video conference mode and submits that the subject matter of the writ petition is pending before the Supreme Court. Pustam. She submits that the diary number of the matter pending before the Supreme Court, which would cover the present case, is 5898/2025, which has been filed in the Supreme Court on 1/2/2025. Pustam. She submits that though the matter has been listed in the Supreme Court, the matter did not reach. The matter was not taken up. Pustam. Next paragraph. It is surprising that even after a matter has been filed after more than a year ago, the matter has not been taken up. The same may be due to the petitioner not making a request for the same. Pustam. As this court cannot keep the matter pending without any interest being shown by the petitioner to have the matter heard before the Supreme Court. There is also no cause list produced to show that the matter had been listed before the Supreme Court, before the Honorable Supreme Court.
My lords, I can present the cause list right now, my lords, if I can share the screen. And my lords, we have not personally filed.
Show me.
My lords. My lords, is it visible? The matter was taken up on 12/1/2026.
12.
Yes, sir.
Yes. Okay. So the last sentence you can cut, huh? when is the next date? When is the next date before the Supreme Court?
So it is not showing right now. Listing dates.
So you all take steps to have it listed. Otherwise, this matter is pending. Or we'll decide this matter.
My lords, we have not filed the petition before Supreme Court. We are waiting for the judgment because the notification in our matter is currently pending before Supreme Court in these matters.
Okay, so you did not file this.
No, my lords. We are waiting for the decision of the Supreme Court.
So the case that is the challenge made in the Supreme Court is with regard to which judgment and which order?
Challenge regard notification of notification number 09/2023 and notification number 56/2023. That is annexure 23 and 26 of our petition.
No. Okay. So no, it has been challenged before the High Court earlier? Or it has been challenged directly to the Supreme Court?
Sir, it has been challenged before the High Court.
So where is the
Now,
High Court decision?
This is the matter in that further goes to Supreme Court, sir.
So where
Messrs.
is the decision of the High Court?
Your Lordship, I can present it in the next hearing date, Your Lordship.
Which High Court had decided the matter?
Telangana High Court, my lords.
Telangana High Court had decided the matter.
Yes, my lords.
So are we bound by the judgment of Telangana High Court?
No, my lords, but we are currently waiting for the Supreme Court judgment in this matter.
But we don't know when it will be decided.
My lords may fix the matter for another date. We will argue on.
What is the judgment passed in Telangana High Court? What is the case number? Party's name?
So the party's name is Messrs. HCC -SEW MEIL -AAG JV.
AAG JV.
Yes.
Venture. JV in brackets. It's a joint venture.
Yes, my lords.
Versus
Assistant Commissioner of State Tax.
number?
1 minute, my lordship. I'm just giving it. Radhika wala hai. It's next day, my lords. My lords, we will present it in the next day.
What else? Next page, next para. Ms. Sakshi B submits that the matter pending in the Supreme Court is from a judgment of the Telangana High Court in the case of Messrs. SCW MEIL AAG JV versus Assistant Commissioner of State Tax. Full stop. She submits that she does not know the number of the case which was registered before the Telangana High Court, and the particulars would be provided to this court on the next day. She also submits that the matter before the Supreme Court had not been filed by the petitioner, and as such, she does not know the status of the said case as on date. Mr.
Maslesov.
Learned Counsel appears on behalf of Mr. Z. Kulno, CBIC.
Lordship.
Are you filing anything? You have filed.
Lordship, we have to file our affidavit in opposition.
When are you going to file?
Lordship. After 3 weeks.
After, give me outer limit, how much? 3 weeks can extend up till kingdom come also. You have to give the outer limit. 4 weeks, 5 weeks, 1 year, 10 years.
Lordship, 27th of February.
Today is what? Okay, is granted 5 weeks time to file affidavit in opposition. This is the matter after 5 weeks. Give it a date on 27th February. Or 27th February? February you mean? Okay, granted February. Is granted 2 weeks time to file affidavit opposition. This is the matter on 27/2.
My lords. My lords, the Honorable Supreme Court has issued the notice. I can show you the order.
You give all your facts, all the cases, everything, okay, in the form of an affidavit the next date, okay? Small affidavit. The petitioner shall submit all the particulars with regard to the matter pending before the Honorable Supreme Court, such as case number, parties' names, and
My lords, I just wanted to bring in notice that this was a bunch of matters wherein different high courts judgments were challenged. So this is not a.
Madam, you give a thing, you give an affidavit, okay? You cannot give your submissions in piecemeal, and especially when I have started my order, huh? What have I said? And the High Court and the Honorable High Court, which had disposed of the validity of the office notification number 09 of 23 and 06 of 23. Correct? This is the matter on 27/2.
Did you oblige, Lordship? Lordship, there's interim order to continue.
We are for whom?
Lordship, I'm for local council for petition.
My lords, please, interim order may continue, my lords.
You give the affidavit.
My lords, can it be given any other date? My senior counsel is not available. My senior.
You just make a small list. We want to know the exact thing. That's all.
My lords.
The particulars of which decision made by this High Court in this case number, all those particulars.
My lords.
Interim order continue till 27/2.
For admission, item number 5.
My
Yes.
lord, I appear for respondent number 6 and 7, my lord, Power Grid Corporation of India Limited. My lord may recall, my lord, last time also this matter had come before my lord's bench while my lord was here. My lord, there was a tower in our transmission line beneath, on top of a hillock, beneath which the petitioner had started doing mining activities, which has made the towers now a bit unstable, my lord. So accordingly, my lord, they had filed this petition for shifting. What has happened, my lord, since the tower is now unstable, we have constituted our own committee and we are in the process of shifting the tower line now. My
Okay.
lord, so in that regard, my lord, survey has happened, meetings have happened and matter has progressed ahead because it will make the tower unstable now and we don't want to take a risk, my lord. My lord, the shifting process has not been completed. The reason being is there is an adjacent landowner, because if the line shifts, my lord, from the current position, it will have to come through in the new alignment route of the on an adjacent landowner's land. So, my lord, the talks were going on. He has shown certain resentment and reservations with regards to the amount, the degree of shifting which will happen. So, my lord, I may be allowed to file one affidavit to bring these latest developments and communications on record, which will help in better adjudication of the matter, my lord.
Okay. Yes.
Lordship, yes, as my general friend has said, on the last occasion, you were supposed to keep the updates. Now, Lordship, just I want to make a short submission. Right, you have every right to go for this constructing this electric line door. But in here, though this, I'll be giving some time to make a reply on the counter affidavit. But when I've gone through the counter affidavit, admittedly, they have said that the land which is occupied by the landlord does not come under the compensated area, as per the RDR reply. That also they have admitted in their counter affidavit. Now, my lordship, my humble submission is that though we are not obstructing for other way of the electricity boards, this and that, but there should be a proper due process of law by compensating us because they have stopped because of that restraining order. The scoring of stone, which is I'm carrying on, which is my livelihood. Because of that, it has been stopped. So, see, lordship, that is my humble submission. And then, as my learned friend has said, they are supposed to keep a fixed time frame when they are going to shift at the tower of 152 to some other place, because even they have to the end of awarding the
Look,
contract.
Mr. Council, you see, there is one thing.
Lordship.
This electrical supply, the towers.
Yes.
They're supplying electricity to thousands of people.
Right.
Okay. Now, because of maybe the electric line is not going through your land.
Right.
But because of your quarrying, you have made the tower unstable.
Yes.
Okay, so basically because of your quarrying now, they have got to move the tower. In fact, you should be paying them compensation. You have made the soil unstable. It is, you see, in these hilly areas, what happens, and there's many cases in my state also, where the road is like, the cliff is like this, there's a road here, the person starts digging out here, the entire hill falls, and 4-5 houses. So same here, thousands of people are enjoying electricity. You have started quarrying below the tower, in your land, no doubt, but thereby making the soil loose and have destabilized the tower. Now, why should not you pay for destabilizing this?
Lordship, my other submission is there. My other submission is there. See, I'm not going to abstract. But the only thing is that because of the restraining order, I was stopped.
Better that you lose some profit than thousands of people lose profit because they cannot get electricity.
And then
your interest, when juxtaposed with the interest of thousands of others, that
appreciate, Lordship. I appreciate.
You cannot have a better right than
Lordship, I appreciate.
the thousands of other people.
Lordship. And then
you see, today I was walking.
Yes.
I walked to the science college in the morning. And near that, I forgot that place where the water point is.
Yes.
Just before Jotsama, gate, there's a water point.
Right.
And just before that, there is a house being constructed down below, from right down below.
Right.
And that is a big house being constructed. Now, what I've noticed is that road,
Yes.
just directly on top of that house. Now that road has sunk. It is because of his construction work. That much I know. Because I've seen this happening in many areas. And it is because of that person not doing good, having geological survey done and measuring how much load the soil can take and all that. Now, because of that, that road has sunk. Now, that road, in a monsoon time, water will go in. I don't know. It's going to be bad condition. Probably there'll be a small mini slide also there. So, same thing what you're doing. You're only thinking about your profit.
Lordship, as per your statement, from the tower, the distance is around more than 13 meters.
13 meters is very small. 13 meters and 13 meters from here to from that thing to that wall.
And then Lordship, there is no indication about the perimeter by the respondent. And then if we are not, as I say, we are willing to stop the stone quarry, but the thing is that as per the process as given to some other landowners, why not we also keep that same opportunity by giving the compensation by following the due process. That is only our submission.
Have you stopped your stone quarry?
Yes.
Yeah, good. You should.
Because
there's no question of allowing you. In fact, you should be. If they file any case against you, you might have to pay cost.
My lord, this transmission line, if I may, my lord, is one of the major lifelines for Nagaland because we are evacuating and bringing electricity, of which they are a part from Palatana and Tripura, my lord. And over 50 megawatts is being brought from this transmission line.
So there's a stay order issued to you by whom?
By the Deputy Commissioner.
By the Deputy Commissioner of which district?
Mokshung. Yes.
At least this court is not in your favor. That much I'll tell you.
But Lordship, my humble condition is that they have not acquired my land, and then see.
Why should they acquire your land? You have now. You are only thinking about your profit. But you're forgetting that because of your quarrying, you have destabilized the area in which the tower is standing, and thereby now making it dangerous for electricity to be supplied to thousands of your own state people.
And then they have also awarded the contract for shifting of that tower to some other place. Thereby meaning it is with what they are saying is they are going to shift the location.
Then naturally they cannot, because you have destabilized the land. It's not safe for the tower to be there.
More particularly in the state of Nagaland, we have a private land. This is a private land.
So?
And then after due examination by the district administration, if proper assessment is done.
There's no question, Mr. Counsel. Right. Heard, Mr.
Estimate.
Learned Counsel for the petitioner and Mr.
State
and Mr.
LT Sanktam.
LT Sanktam for the state respondent. Mr.
N. Khera, my lord. N. Khera.
N. Khera appears for the Power Grid Corporation. What?
My lord, Power Grid Corporation, my lord.
Power Grid Corporation. Mr. N. Khera is granted how much time?
My lord, 2 weeks.
2 weeks.
We'll file it in 2 weeks.
2 weeks time to file. Additional affidavit? What?
My lord, additional affidavit.
Additional affidavit. Next paragraph, right. The petitioner is agreed by the restraining order dated 18/5/2023 issued by the Office of the Deputy Commissioner Mokokchung. Inasmuch as the quarrying activity undertaken by the petitioner on his land, which is beneath the land on which a transmission tower is located, has destabilized the land on which the land on which the transmission tower has been constructed. Full stop. Next panel. The destabilization of the land has required the Power Grid Corporation to shift the tower to a safer place. Next panel. Though the petitioner's counsel submits that the restraining order has affected the petitioner as he cannot continue his quarrying activity for which he would have to be given compensation. This court is not at all sure whether the petitioner would have any right to the same. Keeping in view the fact that it was due to his quarrying activity that the land which was the land on which the transmission tower was located had become destabilized. Thereby, not thereby, which could affect thousands of people within the state. It is also the case of the Power Grid Corporation that the transmission tower provides electricity to major portion of the state of Nagaland, correct?
My lord.
Full stop. The additional affidavit be filed within 2 weeks. Leaves the matter on. Give after 2 weeks.
My lord.
2nd March.
My lord. Highly obliged, my lord.
For admission, item number 6.
Yes, Your Lordship. Your Lordship, I received the amended petition only this morning, for serving the notice to the Deputy Commissioner, newly implemented. So Your Lordship, sometime may be granted to me. So with that, I'll cut my.
These are very. These church, when they fight, it's big problem. Lot of pressure. I also had occasion to be involved as a lawyer in fight between two factions. Anyway, right. So
To serve the notice to the Deputy Commissioner and to receive the instruction and try like this.
Okay, Ms. Livika, learned counsel for the state government, submits that she needs some time to serve notice to the Deputy Commissioner.
That's point number 8.
Bracket was point number 8. How much time?
Few weeks, Your Lordship.
To serve notice?
No, Your Lordship, to receive instruction also, so that means.
Okay.
Like an
She also seeks time to seek instructions. Leaves the matter on. Give a date when you're long. Third March.
Interim order to continue.
Interim order to continue. Till the next date.
For orders, item numbers 9 to 13.
Yes.
Yeah, please, my lord. My lord, in item number 12, that is WPC 43 of 2025.
Yes.
As per the last order, implement was allowed, respondent number 3 to 9. So today notice has to go.
In item 12.
In item number 12.
What about the other items?
They are already impleted, notice complete, but none has appeared. So here the delay was because of the original petitioner expired, so the present petitioner substituted.
In item 12, what is to be done? You said the notice has to go.
Notice has to go.
To whom?
Respondent number 3 to 9.
Right. In item 12, issue notice to the respondents number 3 to 9. petitioner to take steps for service of notice on respondents number 3 to 9 by speed post within
3 days.
within 3 days. It is the matter after 4 weeks. Then in the other items, you just write, no one appears for the respondents number 3 to 9. It is the matter after 4 weeks.
Obligation.
That's all.
For orders, item number 14.
Please, Your Lordship, I receive a rigid instruction.
Yes. Have you got this?
Lordship, I'm just reading about here, the judgment was passed on 12/6. It should be affected, they are similarly situated, Lordship, same advertisement, same selection. Then we have filed this writ petition even prior to they filing a review petition in the Supreme Court. And so it should be, the benefit should be extended from the date when the writ appeal was.
As per 9 of 2020.
Of course, Lordship.
Has to be if they are similarly situated.
Lordship, they were on the waiting list and they were never party only after in the year 2025 only they filed.
In the year 2025. Oh, okay.
This petition is filed only in the year 2025.
What has happened is we did not join the first group who filed the writ petition because the first group's salary was reduced to 25,000 by the state government, whereas our salary 31,350. Our salary was not reduced. That's why we did not join the group whose salary was reduced. That was the fact of the disposition law. So when our salary was not reduced, on agitation, everything is all the same. We agitated before the government, and we were also part and parcel, all the with similarly situated person who approached the court first. In the meantime.
No, you have come only in 25, madam.
Of course, Lordship. But we did not join the first portion because our salary was not reduced. Our salary was not reduced. We were getting 31,350.
But you cannot write piggy bank on the backs of others.
Lordship,
WA 9 of 2020 was disposed of on 2022, 16/3/2022.
Yes, Lordship.
And then you have come to this court in 25 on the basis of the writ appeal.
Lordship.
Then?
What has happened is the principle applies, and Lordship, I raised my case on 2015 one SCC 347. My Lord will kindly appreciate that when particular set of employees is given relief by the court, the other
what is the party's name?
Party's name is State of Uttar Pradesh and others appellants versus Arvind Kumar Srivastava and others respondents.
Shall we give me the citation?
Please. 2015. We have submitted to the library. 2015, 1 SCC, page 347.
And you have filed this case only after Supreme Court has just passed the order.
Yes. Lordship, for us, the set of employees went for appeal. And whatever will be the outcome of the appeal, Lordship, paragraph 22. 22
Wait,
and
just a
22
minute. Just a minute.
Lordship. We are not fence sitters, Lordship. That is the issue here.
Okay, we'll see.
Yes, Lordship. Our salary was not reduced.
Yes. A page, para?
22.
Yes.
The legal principle which emerges from the reading of the aforesaid judgment cited both by the appellants as well as the respondent can be summed up as under 22.1. The normal rule is that when a particular set of employee is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently.
Read the next paragraph.
However, this principle is subject to well-recognized exception in the form of laches and delay, as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and acquiescence into the same and woke up after long delay, only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts. Then such employees cannot claim that the benefit of the judgment rendered in the case similarly situated persons be extended to them. They would be treated as fence sitters, and laches and delay under or the acquiescence would be a valid ground to dismiss their claim. Now, Lordship, here I humbly pray before the Honorable Court that we are not fence sitters because, as I have already said in the writ petition, the first writ petition, when we filed, salary was reduced to, we were getting the first.
Which is the first? How many writ petitions have you filed? This is the first one.
This is, we were, this batch, we were.
You have filed only this writ petition?
Yes, Lordship.
You have not filed any other writ petition?
No. The first batch who filed the writ petition, all similarly situated,
You see, those earlier writ petitions, you were not a party?
We are not party.
You never had any problem?
No.
You never had any problem. Your only problem arose after the Supreme Court judgment passed.
One aspect, Lordship. We were all selected under the same advertisement.
Okay, tell me the entire story from the beginning. Tell me what is the story.
In the beginning, the first batch, the first 435 person approached this Honorable Court in writ petition 174/2018. And by
174 of 2018.
Yes.
Yes.
They approached this Honorable Court. Prior to filing of this writ petition, there were so many agitation going on.
And they were aggrieved with what?
Lordship?
What was their grievance?
Their grievances is that their salary was reduced from 31,350 fixed pay salary.
5350.
31,350.
To
25,000 by the central government in 2018.
And they were working as
graduate teachers.
Graduate. And you were also working as graduate
teachers.
And you were getting the pay of 31,000?
31,000.
350.
Yes. Then at the time of agitation, we came across that our appointment was our appointment was met in a state post creation post at the time of agitation. That came to our knowledge. We were getting 31,350, all of us. Then at the time of agitation, we came across that we were appointed in state post creation post with a
In a sanctioned post.
in a sanctioned pay band post. That's why we approached this honorable court.
You did not approach.
We did.
The other petitioners, not these persons.
These persons, now the present petitioners, our salary was not reduced.
So these petitioners never approached.
We did not approach because our salary was.
So some graduate teachers, not all, some graduate teachers'
salary was
reduced.
Yes.
Now those persons went to court.
Went to court.
And they went to court in 174 of 2018.
Lordship.
And what did they pray for?
They prayed for giving us scale pay. Our post-creation pay.
Because during the proceedings, they learned that this was they were appointed against sanction post.
Lordship.
Regular sanction post.
Regular sanction.
Correct. So they learned that they were regular sanction posts, and accordingly, then what did the single bench say?
Single bench, we prayed for regularization. Honorable court.
We also prayed for regularization.
They paid for regularization.
Both scale pay and regularization.
No, the regularization has not been prayed.
Yeah,
we asked for.
That is not pressed.
I will appeal. No, Lordship.
No.
At the time when our salary was reduced to 25, we approached this honorable.
It's not you. You cannot say we.
Well, yes,
the others.
Lordship. The other group, they sought for granting us the post-creation pay band. Then the single bench granted us.
Where is that order? Where is that order?
Lordship. $128. The operative portion is at page 182. This is a single judge order, Lordship. 182, paragraph 20. Allow me to read out, Lordship.
Just a minute. So, but this court, the single bench did not say that you should be given pay scale. It only set aside the lower.
Yes, the 25 rupees
25.
thousand reduction.
Then
The single bench granted us our original pay, that is 31,300 and 300
original fixed pay.
year, that already
Ah.
fixed pay. So we approached this honorable court in the writ
Writ appeal.
appeal for granting us
Pay
our
scale.
skill pay, post creation payment. Lordship will come to page 232. Paragraph 19 is the operating portion.
Is this the only matter we have left?
Probably, Lordship.
Okay. Hearing matters, good.
Yes, Lordship. The only matter. Hello.
Anyway. When did you get to know? When did those persons get to know that they were entitled to pay scale?
At the time, when they were agitating.
That was
When
for the
at the time
repetition.
when there's after coming to know of it, their salary was reduced to 25.
Okay.
So those whose salary, all of them were agitating together. Those salary who
Before going to the court.
Lordship.
They got to know before going to the court.
Yes. So when salary was reduced, those whose salary was reduced came to the court. However, this we the present petitioners, our salary was not reduced.
But all of you all knew that you all were supposed to get pay scale prior to filing the writ petition.
Lordship.
Correct.
And our intention in approaching this honorable court is that our salary was not reduced. So at the time when the first batch approached this honorable court,
so you all accepted so you all did not agitate that you should have gotten your pay scale. You did not agitate.
Lordship, the first instance was the reduction of the skill pay. That was the cause of action.
But then you said that agitation was prior to reduction, no? Prior to reduction.
Lordship, when our salary was not reduced, we did not join the.
When did you get to know that you are entitled to pay scale?
After this, people approached the court, the first batch.
In the writ petition?
in the writ petition, Lordship.
They got to know prior to the writ petition because they prayed in the writ petition for pay scale.
Lordship, I humbly pray before the Honorable Court, one aspect is that till date, the first batch who approached the court, as well as we are getting the same salary till date, 31,350.
Let me see this.
The respondent has not taken any step yet. We are all in the same, at par, same category.
So they got it from which date? From the date of the order. Forthwith, they said.
Till that it has not been implemented.
Okay, not implemented.
Not implemented. That's why we are in the same at par with each other.
So till now they have not been given.
Not implemented.
Read-able direction.
Ha.
In page 222.
I know it says that pay to the petitioners forthwith.
Yes, forthwith. But it has not been implemented.
Forthwith will be from 16/3/22.
Yes. After that, Your Lordship review went and it got dismissed, Your Lordship. So now it's under process, Your Lordship.
Okay.
No, SLP was first filed.
Your Lordship.
So you take a decision on this also.
No, we can take a decision, but the only limited prayer is that, Your Lordship, it should be from the day of passing of the judgment of the present order, Your Lordship.
It has not been
Your Lordship, Your Lordship.
You see, if you had already given, then it would have been okay. But then now.
Exactly, Lordship.
That is my huge amount, Your Lordship. And they have come only after the writ appeal, Your Lordship.
Our salary was not reduced. That's why we did not approach this honorable court.
And after the Supreme Court has dismissed the order, Your Lordship, they have come before this court, Your Lordship. Only after getting the positive result, they are coming, Your Lordship. So Your Lordship has to see this perspective also, in this perspective also. So from the date of passing of the present judgment, Your Lordship.
You see, there is one thing, madam. The division bench order was passed in 2022.
Lordship. We went for appeal.
They went for an appeal, then Supreme Court dismissed it in 2025. Only after that you have come.
Yes.
So basically you are riding piggyback on their judgment, but you are entitled to know that. You have got a right to it, no doubt.
Of course.
You have got a right to it. So we'll direct that, let them take a decision on that. And if they keeping in view this para, but once they take a decision, if it is against you, come again.
Lordship, because the submission the instruction that has been given, that may also be recorded 1% disorder, Lordship, and yes, we are also not actually the letter also it's not denying the Lordship, but it should be from the date, Your Lordship, from passing of this order.
Lordship, the previous order is under contempt.
They were just sitting and
because since 2022 we have filed contempt in the first batch. Contempt is still pending before the honorable court.
But madam, you should. They are also eligible.
Exactly.
They are eligible, but why they were waiting, Your Lordship?
No. We are
they thought that everyone will be given the same thing.
Because the law is settled. The law is very clear.
Your Lordship, here the consent is very clear, Your Lordship. So that is our submission, Your Lordship. It's up to the court, Your Lordship.
That much I know.
Here consent is very clear, Your Lordship. At least they should have come immediately as soon as, at least to the point that when the division bench, Your Lordship.
Okay, right.
The order passed in their favor. They should have come.
Lordship, they should consider our case. We are in the same
Waiting for
boat.
that appeal. Supreme Court
They have not implemented, they have not changed any stance.
No, but then you see, what about this para 22.2? This is against you.
No, Lordship, fence sitters, in most of the cases, it's about 10 or 15 years and approaching the court after retirement, coming again after. But I think those are the instances where fence sitter is
Okay, right.
explicitly said,
Right.
Lordship.
Head Miss K.Z. Momi, learned counsel for the petitioner.
Their case can be considered complete.
Also heard Miss Livika,
was
learned
the
government
legal
advocate. Yes, still government advocate, not senior.
She's not in the system.
Okay. The the petitioner's case is that they should be given the pay scale of rupees. The case of the petitioners is that they are working as graduate teachers, and that they should be given their post creation pay band of rupees 9300-34800 with grade pay of rupees 5400 per month, as has been given to their counterparts in terms of the judgment of the division bench of this court in WA number
WA 9 2020.
9 of 2020.
It was passed on.
Amos AMOS, then SEB, and 434 others versus the state of Nagaland and 6 others, which was disposed of by order dated 16/3/2022. The petitioner's further case is that the order dated 16/3/2022 passed in WA 9 of 2020 was put to challenge before the Honorable Supreme Court by way of an SLP, which was dismissed on 20/05/2025. Next paragraph. The petitioner's counsel submit that as the petitioners are similarly situated as the appellants in WPC WA 9 of 2020, they should also be given the
Extended the same benefit.
post creation pay band as has been given to the appellants, to the appellants. In this regard, the learned counsel for the petitioners has relied upon the decision of the Supreme Court in the case of State of Uttar Pradesh and others versus Arvind Kumar Srivastava and others, 2015, 1 SCC 347. Next para. Miss Livika, the learned government advocate, fairly submits that the petitioners are entitled to be given.
Your Lordship, as per the instruction.
Actually,
Yes.
but that is your submission.
Yes, Your
So I'm
Lordship.
going to mention this.
Yes, please.
Fairly submits that the petitioners are entitled to be given the post-creation pay ban of rupees 9300-34800 with grade pay of rupees 5400 per month, as has been given to the appellants in WA number 9 of 2020. She, however, submits that
Your Lordship, my humble submission is that.
and as per the letter number ED/CON/HC-23/2025/09 dated 9/2/2026 issued by the Principal Director, Directorate of School Education, Government of Nagaland. Pustak. She, however, submits that the benefit of the post-creation pay ban should be given to the present writ petitioners only from today, as they have filed this writ petition only after the Honorable Supreme Court had dismissed the SLP challenging the order dated 16/3/22 passed by the division bench of this court in WA number 9 of 2020. That's all.
Yes, Your Lordship, I was also about to bring all this thing on by record, but however, the court was of the view to bring only the instruction. That's why I was able to find that.
That's enough.
Your Lordship,
no record can.
You see, the law is clear.
Yes,
exactly.
The law is clear. The only issue is from when.
Yes,
When? It should be from earlier or this. That's the only thing. Because you see, one thing is there, madam. Supposing I say from today, they'll go and appeal. Supreme Court will say from that day.
Exactly.
Lordship, but my prayer is that, like, my prayer of on fence-sitter and all this thing, because we also have.
First up, she submits that the petitioners being fence-sitters and have the benefit claimed by them has only been made after the appellants in WA 9 of 2020.
Because Your Lordship, if W was actually dismissed, Your Lordship, I mean, they could have become a party.
The appellants claim in WA 9 of 2020 had crystallized by dismissal of the SLP by the Supreme Court. What is the Supreme Court order?
Supreme was also filed.
Where is the SLP in the order? Where is that page?
SLP is last page, Lordship. Page 234.
234.
234. Review was also filed, Lordship.
In special leave to appeal, see numbers 19524/2022.
They also filed review, Lordship.
Who has filed review?
State.
We filed a
Review of the
File review where? Here?
Non-Supreme Court.
In the Supreme
Lordship.
in the Supreme Court
Against the
again.
dismissal.
That's why,
Okay.
against the dismissal.
However, Your Lordship.
And prior to that, we have already approached the court, Lordship.
Yes, Your Lordship. That's why I'm saying that before,
No,
after the Supreme Court
It
dismissed.
doesn't
it,
matter. It doesn't
Yes,
matter. How
my
does it
submission
matter?
is up to that extent.
Where is the review? Where is the review case?
I have placed in the record, Lordship.
It's on the record.
Lordship. this is-
Acha, okay, this is the one.
Yes.
What have I said?
They have come into
So
this
sorry.
court.
Review,
There are-
review.
He also,
direct-
first of, he also submits enough. He also submits that the review petition filed by the state of Nagaland
45646.
just a minute, madam. Why diary number 45646/2025 has been dismissed by the Honorable Supreme Court on 15/1/2026. I have heard the causes for the parties. The brief facts of the case is that the petitioners hearing and the appellants in WA 9 of 2020 had all been appointed as graduate teachers on a fixed pay of rupees 31,350 per month. First off. However, the fixed pay of the appellants in WA 9 of 2020 was reduced to 25,000. The appellants in WA 9 of 2020 thus put to challenge the reduction of their fixed pay from 31,350 to 25,000 in WPC 174 of 2018. That appellants, you make it numbering 435 graduate teachers. The prayer of
435.
435.
Something.
Huh?
435.
That's what I said. The prayer of the 435 appellants in WPC 174 of 2018 was as follows. Where is the prayer portion? Where is that? There are 4 prayers that have been made, no?
Lordship.
At page 222, 222, A, B, 222 and 223, A, B, C, D. Okay. Then next. The next WPC 174K of 2018, 174K, was disposed of by judgment and order dated 20/05/2020 by allowing prayer ABC
Lordship, 222 is in written it.
I know, but that is where it is mentioned about
Lordship.
First up, however, the prayer of the appellants in WPC 174 of 2018 regarding being provided the post creation pay band of rupees 9300-34800 with great pay of rupees 5400 per month was rejected. Next panel. The appellants in WA 9 of 2020 thereafter filed WA 9 of 2020 and the division bench of this court allowed the appeal by holding that the appellants in WA 9 of 2020 were entitled to be given the post-creation pay band of rupees 9,300-34,800 with great pay of rupees 5,400 per month forthwith. Next panel. The decision of the division bench in WA 9 of 2020 was put to was challenged before the Honorable Supreme Court by the respondents by special leave to appeal bracket C number 19524/2022, which was dismissed on 20/05/2025. The state of Nagaland then filed a review petition via diary number 45646 of 2025, challenging the dismissal of the SLP. However, the review petition was dismissed by the Honorable Supreme Court on 15/1/2026. Next person. The letter number dated 9/2/2026, I mentioned this earlier, issued by the Principal Director, Directorate of School Education, Nagaland, Kohima, states as follows. Take it from here. Yeah. Yeah. Okay. The above letter is made a part of the record and marked as an extra X. Next paragraph. The submissions made by the counsels for the parties and coupled with the contents of the letter dated coupled with the contents of Annex X shows that the writ petitioners herein are also entitled to be given the post-creation pay band as is being given to the appellants in WA 9 of 2020. The only issue to be decided is whether the writ petitioners herein would be entitled to be given the post-creation pay band from the date the appellants in 9 of 2022 are to be given, or from the date of the present judgment, the present judgment and order. Present order. Present order, not judgment, present order. First up, next paragraph. In the case of Arvind Kumar Srivastava Supra, The Supreme Court has held that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. First up, not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. First up. The Supreme Court has, however, the Honorable Supreme Court has, however, put a caveat on the above by holding that the above principle is subject to well recognized exceptions in the form of latches and delays as well as acquiescence. First up, those persons who do not challenge the wrongful action in their cases and had acquiesced into the same ACQUIESCED, yeah, acquiesced into the same and woke up after a long delay only because of the reason that their counterparts who had approached the court earlier in time, succeeded in their efforts, then such employees cannot claim the benefit of the judgment rendered in the case of similarly situated persons to be extended to them. First up, they would be treated as fence sitters, and latches and delays and / or acquiescence would be a valid ground to dismiss their claim. Next para. Para 22.1 and 22.2. Wait. However, the Supreme Court further held that the above exception may not apply in those cases where the judgment pronounced by the court was judgment in rem, with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Para 22. Of the judgment of the Supreme Court in Arvind Kumar Srivastava's Supra is reproduced herein below as follows. This 22 will include 22.1, 22.2, 22.3, okay? What we can see from the above is that the issue of not being paid post-creation pay band had been taken up by the appellants in W9 of 2020 in the year 2018 itself. The writ petitioners herein, who are similarly situated as the appellants in WA9 of 2020, have approached this court for grant of post-creation pay ban only after the Supreme Court had dismissed the SLP filed by the state of Nagaland. Thus, around 7 years have passed before the writ petitioners hearing have followed the path of the appearance in WA 9 of 2020. And in that respect, it can be said that they are fence sitters. The only question, no, first up, thus it can be also said that there is a delay of 7 years on the part of the writ petitioners hearing in approaching this court with their claim for being paid the post-creation payment. Full stop. The only issue to be decided is whether the exceptions, the issue is whether the judgment pronounced by the division bench of this court in WA 9 of 2020 was a judgment in rem. Or a judgment in persona. I'll decide, I'll pass the order within these 2 days. No time now. Let me think. Because that is what the Supreme Court has said. 22.1 is there, 22.2 is there, 22.3 says if it's a judgment in rem, then that exceptions will not apply.
Your Lordship, my humble submission is that, Your Lordship, they were actually waiting for appeal for also for the scale of pay, Your Lordship. And this part also, they also know that they should be getting that. They ought to have implemented themselves all along. They were just like that, and only after getting that benefit.
No. So that's why I've said.
Yes.
That's why I've said that look, there is a delay, and they are fence sitters. But if that writ appeal judgment, passing the writ appeal, if it's a judgment in rem, then those 2 negative points against them will not apply. So, if you want, you can look at the division bench judgment. I'll hear you all day after tomorrow if you want. If you want, otherwise I have already decided. You can whether it's a judgment in rem. If you can show that it's not a judgment in rem, then you win. If you show that it's a judgment in rem, then you win. That's all.
One factor is that to be given the time factor, Your Lordship, considerable time may be given.
That all. We won't give time factor because it'll have to be given, but it has to be during a reasonable period.
Because considering the fact, I'm making a very fair submission from both sides, Your Lordship. We have that group of persons which are still in process, Your Lordship, and it's a huge amount, Your Lordship. So considering the financial position of the government also, Your Lordship, now we have to go back to the this is just off the record. I'm just expressing the difficulty of the government, Your Lordship. So, Your Lordship, we have to process that also. If we have to give the payment of that thing, Your Lordship, from 2022. So it has become a huge financial implication. So the court may be gracious to give a reasonable time, the good time, so that while implementing all these things.
Reasonable time is how much time?
Your Lordship, it's let it strike the conscience of the court.
No, you tell me.
I want you, Lordship.
No, you have got to tell me how much time
That's
you want.
actually instruction that I have not received, Your Lordship, but
So how?
I felt that it will be fair enough to submit before your court.
But the first group also is processing only now. So why can't this
Because
group also be analogous with it?
Because madam, money doesn't grow on trees. It has to. They've got to make arrangements for that. They cannot give one shot. And you see, money is difficult. Small state also. Where will they? To give them some time. Small states.
I leave it to your
We are not like big states, no, where they've got a lot of income.
lordship.
Out here, where will the income of the state is very minimal.
Lordship, I leave it to my lordship, genuine wisdom.
No, we don't have wisdom. That much.
Just that whether it's in rim, whether that is in rim or in personam, we both has to satisfy this honorable court
Yes.
tomorrow.
Tomorrow or the day after? When do you want?
Yeah,
When do you want? Only on that point.
okay.
We can give it a try tomorrow.
Tomorrow.
Tomorrow I'd have to.
Thursday is- Tomorrow is
Wednesday.
division bench day. So.
Thursday, okay, leave the matter day after, huh? Same. But you pass the order, we'll complete it.
That should convince the mind of the court.
No, yes. If you cannot convince me, she wins. If she cannot convince me, you win.
Yes.
And if you both don't convince me, then both might lose also. Oh, what?
As part first item, lordship. On Thursday, I have one
okay.
program in the evening.
Okay, list the matters as part.
For hearing,
Only on that aspect.
Yes, lordship. I know that.
for hearing, item number 15.
May I please, lordship, my apology, my lord.
Yes.
We were allowed to file an additional activity. So we will file the additional activity on 2nd of February. But due to some technical defects, the application which we have filed, it was rejected and we have rectified it and we have corrected the affidavit and we have filed it.
Okay. It was rectified today.
So it's
So when do you want?
Friday.
Friday, I don't want to take by hearing matters. Last day, no?
In that case, next.
No, right. Mr. N. Long Kumar, learned counsel for the petitioner, submits that the additional affidavit filed by the petitioner was under objection and the same and the rectification of the defect has been made today. On the prayer of the counsel for the parties, list the matter the next week. That's all. Oh, I thought you said there were two matters. That's why I thought, okay. No problem.